Yes.
Any mention?
Thought correction while your lordship's order, my lord.
Correction.
Thought correction.
Okay, to be mentioned.
My lord, may I have your lordship's kind leave to mention a matter? It's item number 22 of today's list, lordship. It's a suit for eviction. The matter is set for evidence to be led by the defendant, but it is my duty to point it out to your lordship that your lordship, while sitting in division bench, had heard the appeal, my lord.
Anyway, other side is present here.
Lordship.
Let it be called on. I shall pass necessary orders.
Lordship.
Lordship, may I indulge this to mention the matter also. The suit is the year of 2013, my lord.
Yes.
I've already given to the notice to my lord. This already the endorsement track report is delivered.
Yes.
So, lordship, as you lordship's convenient, the matter, this is a money decree suit, my lord. So
At what stage? The suit is
now
now.
the witness action. Then
Okay. Give the slip.
report this lordship this. I original copy of
To mention one suit of 2004. Lordship, I'm paying for inclusion in the list, your lordship.
Okay. Give the slip.
To be mentioned, item number 1, Chandra Prakash Agarwal.
Lordship, I am for the petitioner in this matter, your lordship.
Yes, she is appearing in person. On last.
No, your lordship.
No. Is this matter that?
No, she's not. She's mentioned.
Yes.
Mentioning with your lordship's liberty.
লর্ডশিপ দয়া করে নির্দেশ দিয়েছিলেন আজকে টেস্টামেন্টারি শুট আর জিএ অ্যাপ্লিকেশন লিস্টে আসবে, কিন্তু লর্ডশিপ আসেনি।
ঠিক আছে, পেপারটা দিয়ে দিন, কাগজটা দিয়ে দিন।
একটু দয়া করে লর্ডশিপকে দেবেন।
হ্যাঁ, দিয়ে দিন কাগজ।
হ্যাঁ, কবে আসবে লর্ডশিপ? আদার সাইড নোটিশ রিসিভ করেছে 2nd মে।
ওটাকে দিয়ে দেবেন, টু বি মেনশনড দিয়ে দেবেন।
দয়া করে যদি নির্দেশ
আসলে পরে দিয়ে দেবেন।
কবে আসবো?
2 দিন অপেক্ষা করুন, তারপরে।
হ্যাঁ লর্ডশিপ,
2 দিন অপেক্ষা করুন, বুধবারের পরে খোঁজ নেবেন, লিস্টে আসলে পরে।
দয়া করে যদি বলে আর আসতে হবে না, তাহলে 8ই মে বৃহস্পতিবার।
তাহলে নেক্সট উইকে খোঁজ নিন তাহলে।
আর নেক্সট উইকে তাহলে 12-13।
ঠিক আছে, নেক্সট উইকে সোমবারে আসুন, আমি মানে মঙ্গলবারে আসুন, দেখছি।
লর্ডশিপ, নালে অপোজিট পার্টিরা আমার সব সম্পত্তি আত্মসাৎ করে নেবে।
আপনি এটা
খুব বিপদের মধ্যে আছে, একটা অসুস্থ
পেপার ফাইল চলে আসলে মঙ্গলবারে লিস্টে থাকবে, মঙ্গলবারে আসুন।
মঙ্গলবার। লর্ডশিপের দয়া ভুলবো না।
Lordship, in item number 1,
Yes.
I am for the petitioner, your lordship. Lordship had been pleased to pass an order on 28th of April 2025,
Yes.
extending an interim order in my favor, and lordship had been pleased to keep the matter on 22nd of May 2025, your lordship. But the matter is appearing today.
Yes, let me see
Lordship,
the
we are
আরে ওইটা জিএটা ঠিক করবে রে।
You are appearing for?
the petitioner, your lordship. In GA 18, I'm for the petitioner.
Defendant.
No, your lordship. So far as the suit is concerned, I am for the intervener, your lordship.
Item number, এটা to be mentioned.
17টা।
এটা নাম্বার 1 তো এটা আইটেম নাম্বার 1 ডাকা হলো। আইটেম
That is
নাম্বার 1 এ
74 হয়ে গেছে না?
এটা আইটেম 1, এটাতে
Yes, 17. No,
Okay.
may I, the lordship, the order records that GA 17. The last is GA 74. It will be 17.
okay, this is for correction. So the matter is due to appear on 22nd May.
Yes.
Yes, your lordship.
Yes, record an order.
Lordship, may I just make one submission in this
Yes.
matter, your lordship? Lordship, I have received a specific instruction from my client that talks of settlement are going on. This is a family dispute, lordship. Several attempts of amicable settlement have been made, and the parties are yet again attempting to amicably settle the matter.
Let it appear on 22nd May, I shall see.
Sure.
Learned advocates for the parties are present. This matter is put up for necessary correction in the order dated 28th April 2025. In the paragraph, as the application of the intervener GA 18 by 2023 is only appearing in the list, let the application be listed along with other applications being GA 14 of 2021, GA 15 of 2021, GA 16 of 2021, And
For correction.
instead of GA 74 of 2021, it should be GA 17 of 2021.
Lordship, I was being led by Mr. Dott
Yes.
for the plaintiff.
So let necessary rectification be made. Other contents of the order dated 28th April 2025 remains unaltered.
My lord, so far as the returnable date of these applications,
22nd May.
22nd May. Also, what else?
Extremely grateful, Your Lordship.
Grateful.
Item number 2 and 3 in the goods of Kanhaiya Chikwal.
May it please your lordship, my lord, I am appearing for the plaintiff. My lord, the matter has come up at our instance and I'll indicate the reason. For indicating the reason, my lord, kindly take up this
You are
set
for
of orders.
executor.
I'm for the executor. My lord.
Not executor.
Executor now,
The
now essentially the
executor-
executor because
The
the execution.
executor was passed away long back.
It's my plaint. I'm sure my
The-
learned friend will permit me to
the
indicate what the matter is.
Applicant
The
was taken
reason
up
today,
with-
I can go into
Now
the
you
merits,
have
but it's
been a contentious
it's come up as a to be mentioned at my instance, and I'll indicate to the honorable court why.
and it is
But
without
kindly take up. Of course, it is with notice.
No,
Kindly take up. Kindly take
the
up
matter
the
was
first.
the matter was
My learned friend is
mentioned
appearing,
without
so I do not know
notice.
why
In a
he is
waiting
taking
matter.
that point
What
of.
is to be done now?
My lord, kindly see the last order.
Fixation of
The
date.
last order. No,
for
it's
the
not. It's not
witness.
fixation of date. Kindly see 26th March order. The matter is fixed for 7th of May. The only reason for mentioning
is
and
before
the
the-
only reason
That
for
is before
mentioning
the Honorable
is because
Justice
in
Vivas
these
Patanayak.
orders, your lordship will find
The matter is appearing to eventually on content. Yes,
On
the
the con-
matter is due to appear on 7th of
7th May. I'm only praying our witness action is complete. My learned friend has to bring his witness. From 3rd of December, he's dilly-dallying. He's taking up several pleas by which the witness is not coming. The matter is fixed on the 7th. Let my learned friend not come and say on the 7th that my witness is not coming. It is only for this
No,
reason
I
that we
never-
are mentioning.
I never said anything.
Because today they,
Never said
yes,
anything
they did
to
not
my
say
learned
it, and
friend.
that is the reason I've mentioned.
appeared on 26th March. I
Yes.
believe. So
Your lordship, what has happened
on
on
your consent, the matter was fixed
Well, on the 7th.
May.
Only they should bring the witness on the 7th. That's all.
kindly allow me
Otherwise,
to, kindly allow me to state the fact. On 3rd of December, they concluded their evidence. Thereafter, I intended to adduce my evidence, and that was fixed on the 2nd week of January.
Yes.
The 2nd week of January, matter did not come in the list. My witness came from other state in Calcutta. It's a 80 years old witness.
Now it is the new state.
And
that
But the
story is
matter-
not
the-
made out from the orders. That's the
please-
difficulty.
please, it should be uninterrupted. You have
We-
concluded your submission.
Unfortunately, my learned friend
In-
did not extend that
On
courtesy.
16th of January, the matter was again mentioned as to be mentioned. The next date was fixed on 21st of February. 21st of February, considering the age and the
21st.
witness is staying some other state.
Yes.
On 21st of February, the Honorable Justice Vivas Patanayak did not sit due to some medical reason. For 10 days.
So then
My witness came,
But
in
I-
Calcutta. I can produce
Wait,
with
wait,
boarding
wait.
passes on all
The
occasions.
question is on 26th March. By consent of the parties, it is fixed on 7th May.
I'm very
Due
grateful.
to
That's
change
the
of determination, this date is to be fixed again. That
It
is
will be
why
fixed on
I
the
have
7th.
suggested
We
the 80
expected this will be the
80
submission.
years old witness.
I am
not to
very
come this
grateful
time.
to my learned
Let
friend.
me-
We
let me
expected
mention
this
the
submission will be
matter.
made.
Let the date is fixed and then come.
No, date
I
is
cannot
I'm
praise
praying
the
the date is already
80
fixed.
years
It is
old.
al- no, no,
I
date
cannot-
is
That can't be a
already-
reasoning.
So it is appearing at your instance or Mr. Bag's instance.
It is appearing at our instance because we knew this
They have
prayer will be
mentioned-
made on the 7th.
They have
My lord,
mentioned the
the
matter.
same prayer would have been made on the 7th. And that is the
What is the
reason.
difficulty to bring him? Because you knew the date. What is
Because-
the difficulty to bring him on 7th?
The ticket has been cancelled
They
on
can book
7th.
another ticket. It's a
Please,
flight
due to-
ticket. They can
due
book
to-
it any day.
When it is already.
Because
They should know.
determination has been changed.
So why
Very
will
well
they
is the
expect?
Unless your lordship kindly say that is an 80 years old witness coming from a distant place. That is in a
No,
different
if he is
state.
suffering from some problem, you can apply for
In-
commission also.
In today's age,
Commission
today's
in
day,
some other
this
state.
submission that some
Whatever
from a
it is.
distant
Some
place
other
because of some
state
other
is very
state
difficult.
is unheard of.
No, not a difficult.
Unheard of.
They just a month time.
No, I'm opposing.
Just
I
a
am
month
praying. We
time I
knew
need
this will be the
to
situation.
adduce the
I am
evidence.
praying my lord,
Fix the
kindly
date,
fix it on the 7th.
Kindly fix the date and time.
Fixing it within this month.
My lord, may I only pray for the 7th? May I only pray for the
My lord,
7th? Let
the
them bring the witness, otherwise kindly fix it for hearing.
Reservation of railways and flights are very difficult.
No, it's not difficult. We will arrange for
Very
it if they say
difficult.
that. How can that submission be made? In today's age, he's making a
I
submission
don't
from a
know
very
why
distant
they are
place.
opposing this.
From a distant place
witness is
only
80
because
years
it's coming
old
from
and
another
considering.
state.
Yes, record an order, please.
But I'm only praying for
Kindly
7th.
fix the
Kindly
date
fix
in
it on the
the
7th. Let them
second week
come.
of June.
Mr. Bag, learned
Second week
advocate
of June.
for the applicant
Second week of June. What kind of
and
submission would say?
the
After
for
first after reopening.
learned
I oppose that.
advocate for the opposite party caveated are present by order dated 26th March 2025. It appears that by consent of the parties,
Just
the
witness will not come.
matter is due to appear on 7th May 2025. Mr. Thor submits that due to change of determination, certain arrangements could not be made and last chance be given to him to produce his witness. In the facts and circumstances, this matter stands adjourned till 11/6/2000.
Kindly put it this side of the vacation. I've been teaching you, Lordship. The only reason I handed over those 4 orders. My lord, kindly see the first. Kindly permit me 2 minutes. Kindly see the first order which I've handed over. That's 3rd of December, 2024. Kindly see what is written there. And I'm sure my learned friend. Will give me.
11
I have given that uninterrupted period to my learned friend. He will extend the same courtesy.
I have some
Kindly
personal
see the
difficulty.
Kindly see the 3rd
My
December.
family deity is
Kindly see the
Jagannath, the Lord
second
Jagannath.
page.
That is 11
My lord,
Yes, 11/6/2025 as a last chance.
My lord, it is Snan Yatra. I cannot come.
Yes.
My family deity is Lord Jagannath. This is Snan Yatra.
Kindly keep it
11/6 is
prior to
Snan
the
Yatra. I have
vacation.
to
I'm
make
sure
the
they can come then.
17th,
Kindly keep it prior to the vacation.
Next week.
You see, you cannot come within month of May. Again, you are saying that you cannot come.
Yes, Lord, it is Snan Yatra. It is my family deity is
Kindly
Lord
keep it in
Jagannath.
May. Kindly keep it in May. This is only a delaying tactics.
18th of June.
18th of June.
As the last chance.
18th of June.
May one line be recorded in case they fail to come on that day. The matter will be fixed for hearing. This clarification.
What is the meaning of this one?
I understand that, my lord. Only then it will be fixed for hearing. The only difficulty, my lord, by in any event.
18th of June.
No further time will be granted.
I'm very grateful. Very grateful.
Grateful, your lord.
If he is suffering from some old age ailment, you apply for commission. Or
They
if
will not do that, my lord, because they don't want that to happen. They don't want that to happen.
Cost cannot
I'm very
be
deeply
borne.
obliged.
Cost cannot be borne by the caveated defendant.
I'm deeply obliged.
It is in different state. If it is in Kolkata, I can try and I can advise them to do that. And it is not that he is immobile. The witness is not immobile. But coming from a different state, making arrangement for the reservation of the railway tickets and flight tickets is very difficult now.
you make your endeavor, I've kept it.
18th of June. I am deeply obliged.
Item number 4.
What?
For orders, item number 4.
I beg to appeal.
Mohammed Faizul Haq and others.
I beg to appeal.
Yes.
My lord, it was, my lord, came to forwarders only
Yes.
to the extent.
I think today is fixed for submitting your written notes of arguments.
No, my lord, it was for propounding. The document, impounding, my lord.
Okay. So
Only
for
impound.
further hearing and orders.
Yes.
Where is your application?
My lord,
There is no
application,
separate application.
my lord, I understand, my lord. The law says, my lord, may I, my lord, my lord, have the original copy of the lease agreement, my lord. সার্টিফিকেট দেওয়া আছে অরিজিনালটা সার্টিফিকেট দেওয়া আছে agreement for sale, my lord, is in my lord brief, judge's brief. এটা তো my lord, judge's my lord, God, my lord, judge's brief.
Yes, page 5.
This is the first document.
Page 5.
Page 5, my lord. This is the agreement for sale. It was not, my lord, on the requisite stamp. This agreement, my lord, we are seeking enforcement of specific purpose. So, my lord, it requires to be properly stamped, and for that purpose, my lord.
In this regard, did you make any application for
Lord,
necessary?
application, my lord, may I submit? May I submit, my lord? The law is very clear in this point, my lord. The court himself itself can, my lord, pass order.
Yes, court has the power.
My lord, kindly have a look to section 33 of the
Yes, yes.
with the law. No, Stamp Act.
Give the copy.
দাও এই বইটা দাও আছে My lord, kindly have a look to section 35. Hmm, hmm, hmm. B. And West Bengal Amendment Code. And in respect of my lord, High Court Judge, the duty of examining and impounding any instrument under this section may be delegated to such officer as the court appoints in this behalf. My lord can, or my lord can delegate. 33, my lord, 2B. And 4 West Bengal Amendment, it says, my lord, on a reference from a court, unless
And 4
yes, my lord. West Bengal Amendment, এটা দাও
is not here.
ওই পাতাটা খুঁটা left hand side, my lord, bottom, West Bengal Amendment. Judgment of it. 70.
Okay, this is with regard to West Bengal.
Yes, this has been West Bengal, my lord. I would rely, my lord, on another judgment of Honorable Supreme Court. It is reported in, my lord, 2009 to SCC 532, my lord, para 17. Para 17, last paragraph. We have noticed here to before that section 33 of the Act cast a statutory obligation on the authority to impound a document. The court, being an authority to receive a document in evidence, is bound to give effect thereto. And my lord, 18 also. The court therefore empowered to pass an order under section 35. 17 and 18 I would rely, my lord. So court himself has the power to.
Court suo moto has the power.
Suo moto power. Because, my lord, every authority includes court. My lord, when a document is produced, it is unstamped or below stamped. Court has the suo moto power to refer it or to impound it. Refer it for impounding. They are ready and willing to, my lord, pay the my lord, deficit, my lord, stamp duty. Because in West Bengal, my lord, it requires, my lord, as per clause 23, that is as per sale, my lord, market value on the market. কত আর্টিকেলটা কোডটা এই যে কোড is 23 এখানে agreement for sale. My lord, it takes up, my lord, stamp duty on instrument in West Bengal, schedule Roman 1A.
So it is 5% of the
in Calcutta 6%.
6% of the property value.
Property value.
And this is this here, how much stamp duty is paid?
10.
10. Okay. Yes, record and note. Learned advocate for the plaintiff and learned advocate for the defendant are present. Hard learned advocates. In this matter, the affidavit of documents are filed by the plaintiffs. It appears that the document being deed of agreement for sale dated 12th day of November 2009, which the plaintiff seeks to enforce in this suit for specific performance of contract is executed with stamp duty of rupees 10. However, the stamp duties in case of agreement for sale is the 66% of the.
My lord, as per my lord, clause 23.
As per?
My lord, clause 20. May I, my lord? May I open?
The stamp duty with regard to the sale of immovable property.
Agreement for sale.
Agreement for sale
of same as conveyance 20.
Immovable property.
I have one submission, ma'am.
Yes.
Actually, we have challenged this document only.
Whatever it is, that will be decided in the time of suit.
At the time of
My lord, kindly direct them to let them come with a.
No, first of all, it has to be impounded. First of all, it has to be impounded. As per the stamp duty on
2009, they have not registered. No, they did not file any separate application for.
On instrument in West Bengal is 6% of the market value in case the property does not exceed rupees 1 crore. However, in the facts and circumstances of the case, as the plaintiff has paid rupees 10 stamp duty, this court is of the view that this document should be impounded as per provisions of section 33 of the Indian Stamp Act.
33 and 35.
33 and 35 of the Indian Stamp Act 1899. Thus, this document, agreement for sale, dated 12th day of November 2009, is impounded and sent to the collector. Sent to the Calcutta collectorate to assess the stamp duty and submit a report in this regard. Let this file along with this order be sent to the register original site to send the matter to the collector for assessment of the stamp duty and for submission of the report. Let this matter be fixed on 18/6, month of June, 18/6/2025 for report, for necessary report in this regard by the registrar original site.
Grateful, madam. To disclose the document. My lord, in the meantime, my lord, defendants, since my lord, defendant have not disclosed their documents, my lord. In the meantime, there may be a direction to my lord.
Yes. In the meantime, the defendants are granted liberty to file their affidavit of documents.
Discovery of documents. Grateful, madam.
New motions, item number 5, Kantimay Kundu Chaudhary and others.
Mr. Shorajit Dasgupta is appearing on behalf of the petitioner.
Yes, item 6, item 5.
Yes, Lordship. I am praying for not today.
Okay, not today.
Sorry. Item number 6, Subhash Shatuka and others.
Yes, pass over.
7, Pashupati Datta ভোট চলছে তো 8 পাশুপতি
আমার petition, আমি তো করি।
Item 8.
7 and 8 both, my lord, I appear for the plaintiff. My lord, there was a direction for amending the plaint, and the amended plaint have been served. The writ of summons have been lodged. My instructions are that,
What is this application for GA?
my lord, there are two applications made by my learned friend, one for transposition and the other for appointment of a valuer at the cost of the plaintiff. My lord, in a partition suit, your lordship knows that the parties are all in the same position. A valuer may be appointed at the cost of, to be borne by all the parties.
Actually, after the preliminary decree, as per the shares, the
The shares have been allocated and there is no
preliminary decree passed.
that has been accepted by the parties.
Yes, well, who is for the petitioner?
In this case, he's
I'm for the petitioner, defendant number 1A and 1B.
Hey, देखिए, ये है।
Respondent number 4 APM.
my lord, I am for respondent number 2A, 2B, 2C.
Respondent, defendant.
Dependent.
You are for the plaintiff.
I am for the plaintiff.
2A, 2B, 2C.
Hey, application to din. This is GA 22 of 2025.
GA 22 is for transposition application, my lord, and GA 18 for
18 is for appointment of,
valuer.
my lord, your lord.
Regarding transposition, you have
My
filed
lord,
your
your lordship,
No, no,
my
no.
lord, there's no necessity, my lord, your lordship knows. In a partition suit, all the parties are arrayed at the same position, my lord. Absolutely frivolous application. There's no need for a transposition application, my lord. The applications are
What is the
contradictory.
ground for transposition?
Their only ground is that we are not taking steps. My lord, so many defendants have expired.
It's long.
My lord,
Therefore,
yes, my lord. Yeah.
therefore we have
They-
filed this application for transposition, my lord.
Why? What is the reason? My lord,
My lord, the plaintiff has not.
there were
taken
many
steps.
defendants and
My lord,
all
plaintiff
the
has not
original
taken
defendants have expired.
The suit is
What steps have?
1990.
Substituted defendants.
Yes, my lord. Yes. I have taken steps for
How
substituting.
long is the suit pending?
From
Since 1992.
92. My lord,
So it has
that
to
is,
be expedited.
yes, my lord, I am also interested in that.
No, my lord.
Yes, where is the prayer for appointment of valuer?
My lord, in GA 18, my lord.
it is item number 7.
GA 18 is this thing.
A valuer be appointed at the cost of the plaintiff. Why, my lord? All the parties are going to be benefited from the appointment of the valuer.
This matter is not appearing today, the appointment of that valuer application.
My lord, there are two
Both
applications.
No, one is there, this transposition, this application is here. The other
7
application,
and 8, two items.
yes, GA 18 is before this court, but the other
18
application,
is for valuer.
For value,
Valuer.
appointment of value.
GA 18.
Yes,
my
18
lord.
is for appointment.
GA 18.
GA 18, GA 22 is appearing.
দুটো application appear করছে না?
That is for transposition, my lord. A22.
তাহলে ওটাকে বুধবারে আনিয়ে নিন তাহলে।
7 or 8 now.
Okay, let it appear on Wednesday, okay, both the applications.
My lord, may I make a prayer, my lord? Wednesday, I am in some difficulty, and the next week, my lord, I am not here. So can
Tell
it
your
come,
junior to appear.
my lord?
My lord, possibly it is appearing as 80 instead of 18. Serial number 7. Possibly, kindly.
My lord, there is no such application as 80.
There is no such application as 80. It is
Item
The
correct.
number 8
applications which
record
are
doesn't have.
appearing are GA 18 of 2023 and GA 22 of 2025.
Yes.
These are the two applications which are appearing.
Yes.
80, there is no such application as 80.
There is no such
18.
application.
18.
It should be 18. My lord, that may be rectified.
80.
No,
18.
18.
No, GA 18 of 2023. This is appearing in the list.
But the records are not
Records
here.
are not here.
Lordship will take up on 20th May.
Yes. Come on 20th. Or let this application be allowed, transposition
My
application.
lord, why? But
My
then
lord.
I will come up with
Yes, my
judgments,
lord.
my lord. I will come up in a partition suit. All the parties are added at the same
You are
position.
interpreting in this
There is
matter.
no necessity for. My lord, I will come back
You
with
want to
judgments.
submit with regard to transposition?
Yes, my lord. If the argument is that in a partition suit, all the parties are defendants and plaintiffs, but the carriage of proceeding is with the
No,
plaintiff.
in a
But
partition suit,
if,
the
if
carriage
an
of proceeding.
amendment, if an amendment is
I will
allowed,
come
who has to
back
take
with
out
judgments.
Of learned advocates, let this matter GA 22 of 2025 appear along with GA 18 of 2023 on 205 20th of May 2025.
Deeply obliged, Your Lordship.
Grateful.
আপনারা expeditious চাইছেন আবার amendment আবার
কিছুই বললেন 100
Item number 9, Narendra Kumar Barlia and others.
I am appearing for this defendant number 1 and 2.
I have taken this matter in appeal.
Yes.
Lord.
I am appearing for the plaintiff.
And
Sitting with Justice Mukherjee.
regarding interlocutory matter, so I have taken this matter in appeal. So far I
My
recollect.
lord, this particular application is not in relation to the that particular interlocutory application, my lord. These are two different applications for the
But I believe my lord, the hearing could be
plaintiff.
Regarding, you see, one interlocutory application was challenged before the appellate court. Okay.
My lord.
I took up the matter sitting with Justice I.P. Mukherjee.
Yes, my lord.
But my lord, these applications are not in relation to that interlocutory application.
But the suit has to be heard out then.
This my lord,
Because my lord, these
but since your lordship had, my lord, had the occasion, my lord, to deal with the
That
matter,
means you see interlocutory.
The matter went up to Supreme Court, my lord. My lord's order was upheld also, my lord. So, my lord,
my lord, I
as your
believe, my lord,
lordship
there would
Injunction application is also related with the main suit.
my lord.
my lord. And that would not preclude perhaps.
Had it been some other application, addition of party or substitution.
It is similar. My lord, it is in the nature of amendments. There is
an application.
It is an application by defendant, my lord.
one is
By
not an
defendant
application for amendment, my lord. It's
for
an application for
proceeding with the suit. Very innocuous prayer by defendant.
The appeal which was against the refusal of the prayer for grant of injunction.
My lord.
That was the appeal.
That was again my learned friend's clients.
By purchasers and by the
He was appearing for
plaintiff and whatever.
Yes, with the company, my lord, in that matter.
company.
it relates.
Because you see, after all, the main suit cannot be taken by this bench.
But that is what they want, my lord. But the
But I
copy
leave it
which
to
was
my lord.
served upon us, my lord, mentioned the summons, notice of motion returnable on 15th, my lord. Although it is appearing today, my lord.
Yes, record an order. Learned advocate for the plaintiff. You are for all.
Defendant number 1 and 2, my lord.
I am for the plaintiff.
Learned advocate, the plaintiff, learned advocate for defendant number 1 and 2. You are for?
16. My application.
You defend which defendant? 16. For the defendant number 16. And learned advocate for defendant number 15 are present. It appears that this matter was taken up by me while sitting in the division bench against the interlocutory order of refusal to pass injunction. And the said appeal was also disposed while sitting in the division bench. Thus, I'm of the view this bench should not take up this matter. This matter stands released from this bench. Let the matter be placed before the Honorable Chief Justice for necessary assignment.
Next matter is same, my lord.
9 and 10 years, both Barlia matter. 9 and 10, both
Yes,
same.
my lord.
Item number 11,
This is
Paritosh Das.
this is that matter where I have sought for modification of a decree, and Lordship was of the opinion that that the modification.
That's preliminary decree.
Yes,
no.
my
Final
final.
decree pass.
My lord, I require 1 week time to study further, my lord. I have not got hold of any judgment, my lord. Kindly grant me a week's time, my lord. I shall
Then
come.
not this week.
Yes. Obliged.
Matter takes up the next matter, my lord. Item number 10 is in relation to a different suit, my lord. Item number 10, although the cost title is the same,
Suit property is the same.
my lord,
party is
it is a
same, my lord.
partition suit, my lord. Parties may be same, but it is in relation to a different suit proceedings
Same
altogether.
set of parties, my
Better,
lord.
it's
Same set
better
of
for a
parties.
particular
Very
bench
well,
to
my
hear
lord.
both the
Very
matters.
well,
Okay,
very well.
otherwise
Same set of parties.
there may be conflicting
My lord will
decisions.
only record that since it's a different suit, but in relation to the same property. So my lord is with regard to item 10, my lord.
No,
So
but
the
it was
parties are
also
same.
subject matter of appeal.
No, my lord. This suit it was not the subject matter of the appeal. This appeal was part of CS 12 of 2009. CS 79 of 2011 is a different suit for partition.
But the parties were same,
Parties
your
are
lordship
the
can
same. I have no
in item
problem.
number 10, my lord, your lordship can say parties are the same
Since my lord
as
will
in
record that.
item number 9, my lord.
আচ্ছা আইটেম 10 টাকে একটু আলাদা করে দিন হ্যাঁ আইটেম 9 এ যেটা লিখলাম সেটা আইটেম 9 এ থাকলো আইটেম 10 লার্নেড অ্যাডভোকেটস ওই সেম অ্যাডভোকেট যারা আছে ওটা থাকবে হ্যাঁ it appears that the item number 9 which is released by this bench on the ground of being taken up in the division bench relates a dispute between the same parties.
Yes.
Although it is a partition suit, but however, in the interest of justice, it should be heard by the bench taking up item number 9.
My lord.
Passed over item number 6. Subhash Sadhuka and others.
Item 6, okay, not today.
Adjourn motion. Item number 12, first call, Rumi Sain and others.
My lord, this matter, my lord, relates to two suits, and these two suits, my lord, had directed by my lord's order dated 21st April that the suits are to appear together. But my lord, today again in the list, only one of the suit is appearing.
Adjourn motion
Yes, sir.
is GA5 of 2020.
My lord, GA 5 and 6
Yes.
are substitution application and an application for
You
perjury.
are the applicant.
You are yes, lordship.
No, applicant in respect of GA6. GA5 is an application filed by another one of the is filed with regard to one of the plaintiffs as a perjury application under section 340.
Okay, and GA6?
GA6 is a substitution application by the
So let this be taken up GA6.
No, my lord, the issue is in the other suit, which is 143 of 2013, there is a similar substitution application pending. My lord, the substitution application is heavily contested. My lord, both those applications can be taken up together in GA in CS.
Affidavits are complete.
All complete. My lord can take it up, but my lord, I'm playing both the applications are identical. Let both the applications be taken up together.
No, applications are appearing in the list.
My lord, I believe my learned friend would also agree to this. The issue is, my lord, GA5 in the other suit and GA6 here, my lord, the application would be similar.
Actually,
Same pleadings are
They
there,
are talking about another suit, lordship.
which is not appearing in the list. My lord had directed the matter to be tagged 143 of 143 of 2013.
Both the suits, Milord, after Milord vacation, if lordship. So convenient.
Yes, item 12 and 13, record and order. Learned advocate for the
But I am for the defendant numbers 1 and 2 in this particular matter.
Defendant number 1 and 2, and learned advocate for the
applicant
are present. Plaintiff did not appear.
Well, plaintiff is not here.
None appears for the plaintiff. You are the substituted you
Yes, Lordship.
for one of the plaintiff.
One of the
Plaintiff number
plaintiffs.
3, Lordship.
One of the
Yes.
plaintiffs.
Okay. None appears for the plaintiff
In Millard CS 41.
as GA. Yes, which GA is to be heard out?
GA6.
Our contention is that our
My lord, GA5.
GA5.
GA5 of
our
2020.
application, yes, Lordship.
And
And
along
GA,
with
along with GA4 in CS 143 of 2013.
okay, and GA4 of 2020
CS1 of 2020
of CS
143 of 2013.
of CS 143 of 2013
Yes, my lord.
is not appearing. Let this GA5 of 2020 in CS 41 of 2011 appear with GA4 of 2020 in CS
143 of 2013.
143 of 2013. On, yes, when shall I keep it?
If Lordship fix after vacation, Lordship, that will
On the reopening date 9.
My lord, keeps it on 10th.
Okay, 10/6/2025. Item 13 also same order.
Yes, my lord, same order.
Acha. Item 10 is GA6. So it should be heard with which application?
My lord, GA6 is a perjury application filed by a different party.
Okay. Item number 13. Item number 13.
Let it appear, my lord, in the list.
Item number 13. As the applicant who has filed this application GA6 of 2021 is not present, let this matter stands adjourned till 10/6/2025.
10/6, my lord. Much obliged. Much obliged, my lord.
Item number 14, Annapurna Commercial Company.
Your Lordship, I appear for the defendant numbers 1, 2, and 3.
I'm
This
for the
is
plaintiff, madam.
you're for the plaintiff.
I'm for the plaintiff. Madam, there are three applications. The first one being GA number 2, which is an application filed by the plaintiff for injunction in which we are enjoying an interim order. My lord, subsequently, my lord, IAGA number 3 has been filed by my learned friend for dismissal of the suit on the ground that the writ of summons was not lodged. Affidavits are complete in that.
I think this matter was heard. Partly
Yes, my lord.
Yes,
it,
my
it
lord.
was
I had
heard
argued
last on.
substantially, Your Lordship.
It was heard on, my lord, 21st of April 2025.
So what I said is to you file your written notes of arguments
Written
after
notes
the
of
matter
argument.
was heard,
My-
probably.
No, Your Lordship. The
Yes, Mr. Ghosh was there on
Yes,
the,
Mr.
on the
Ghosh,
last occasion.
Mr. Ghosh is leading. Kindly grant sleeve to Mr. Ghosh, my lord.
So Mr. Ghosh argued on the last occasion.
Your Lordship, I argued.
Yes. So
I argued at.
okay, Mr.
He
Mr.
had
Ghosh is to reply.
Yes, sir.
I think he had some things to say, some more things he had reserved his right.
Anyway,
Make
thereafter you file your written notes.
Your Lordship, my written notes is already on the file, Your Lordship.
Let me see that.
Ours also, we had also filed.
Both written notes already on
Anyway,
file.
you have to conclude today.
Yes, Your Lordship. I don't think I'll be taking a maximum of 5-10 minutes, Your Lordship. I'll just revise what I
Anyway,
said,
conclude today.
Your Lordship. Very essentially, Your Lordship, if Your Lordship takes up my application, Your Lordship, IGA number 3, as well as the application of the defendants, of the plaintiff, Your Lordship, that is
GA2.
IGA number 4.
No, GA2 is whose application?
GA2 is the plaintiff's application for injunction, receiver, and other such interlocutory relief.
Any interim order is pending?
A status quo order was granted by this honorable court, which was heard upon notice. We couldn't
Anyway.
appear on the day on which the matter came up.
Anyway, this is an
Status quo was
interlocutory GA2. But first of all, that yes, GA3 is also plaintiff's application.
GA3 is our application, Your Lordship, for dismissal of the suit due to non-service of the writ of summons, Your Lordship.
Okay, GA2.
GA4, Your Lordship, is their application seeking extension of time to lodge the writ of summons, Your Lordship.
GA3.
GA3 is
your application.
My application. GA2 is their application for injunction and interlocutory release. GA3 is my application for dismissal of the suit.
GA4 is there for extension of time.
To lodge the writ of summons. Your Lordship.
Anyway, affidavits are complete in both the applications.
Both the applications. The applications are being heard simultaneously, Your Lordship. Because what I am saying is that there is a 12-year delay in lodging the writ of summons. The writ of summons has not been served on me. I have never received a copy of the plaint. Because even in the past, in GA number 1, which was an application filed by the plaintiffs for injunction as well as other interlocutory reliefs, the plaint was not annexed. In GA2 also, if your Lordship sees, the plaint is not annexed. So I never had notice of the plaint. For the last 12 years, the matter has been pending in the file of this Honorable Court without any steps being taken by the plaintiff. The writ of summons was never served on me. I could never enter appearance. Because if I receive the writ of summons, as I had explained to your Lordship, under the original side rules, it is only when I receive the writ of summons that I can return the writ of summons and then file my wakalatnama along with that, entering appearance, and then I can file the written statement within the number of days provided in the writ of summons for filing the written statement. Your Lordship, that process has not been done. There's a 12-year delay. We have, as your Lordship will see from the record, we have filed separate wakalatnamas with each application.
Yes.
So GA3, there's a separate wakalatnama and a separate affidavit of competency. GA2, even for filing our affidavit in opposition, there's a separate affidavit of competency and wakalatnama. GA4 also, to file our affidavit in opposition, there's a separate wakalatnama with a separate affidavit of competency. Have I been able to clarify the order of the applications to your Lordship?
Yes, yes. So both applications, that is 3 and 4, are interrelated applications.
Precisely, your Lordship. If I show your Lordship the prayers of both, your Lordship will be able to see exactly what I'm talking about.
Notice of motion.
Master summons.
This is master summons.
Yes, your Lordship. GA3, GA4, duty master summons to the Lordship. Lordship has both master summons.
This is GA3.
Lordship has the master summons of GA3.
GA3. GA4 ta dekho. Application to delay हो जाए. Application to have application to prayer देवा. Lordship, in GA4, the prayers are in the application itself at page number 10. Yes.
Lordship has it. Your Lordship, the prayers there are a delay, if any, lodging the writ of summons in respect of CS number 241 of 2012. As the main suit be condoned. Leave be granted to your petitioner to lodge the writ of summons in the suit, being CS number ATO, for service of the same upon the respondents herein. In the alternative, an order be passed waiving the requirement of formal service of summons in respect of the instant suit upon the respondents, and the respondents be directed to file their written statements within such period as this honorable court may deem fit and proper. And my lord, the usual seeking of further relief. If your lordship sees the master summons to GA3.
Yes.
So, my lord, I'm directly reading from the press. The caption suit being CS number 241 of 2012, cause title, short cause title, pending before the Honorable High Court at Calcutta be taken off the file and be dismissed. So, my lord, I'm seeking that it be dismissed. The reasoning I've given in my application. So, one application seeks dismissal of the suit. One application seeks condonation of delay to file the writ of summons and thereby continue the suit.
Yes, where are your written notes? You have filed on the last occasion.
We'd filed when the matter was before the coordinate bench, Your Lordship. We'd filed the notes, both parties. Notes of arguments. That's the plaintiff.
Yes.
That's why Your Lordship will see in the written notes of arguments, I've labeled it as IGA number 3 and GA number 4 because
yes,
same arguments for the same issue.
But affidavits are different.
Affidavits are different. But if Your Lordship goes through the affidavits, whatever I've stated in my application in GA number 3, I essentially repeat in my affidavit in opposition to GA number 4. Whatever my learned senior friend has stated in their affidavit against GA number 3, they state in their application in GA number 4. Your Lordship, the essence of the arguments as they had been advanced by the both of us before the learned single judge previously was that I am saying, Your Lordship, very essentially, I can reduce it to 4 points. In 2012, the suit was filed. In 2012, an application seeking interlocutory relief, injunction, and that kind of relief was filed. The matter came up for hearing before a learned single judge of this honorable court. Said learned single judge passed an order directing the completion of affidavits in the matter. In the meantime, His Lordship was pleased to direct that I do not take adverse steps against the plaintiff. I am the association of the flat owners, wherein in the apartment, wherein the plaintiffs own 5 flats and certain car parking spaces. So I was directed to not take adverse steps. They were directed to pay the maintenance charges. Affidavits were directed to be exchanged. Affidavits were exchanged. Then, my lord, on 7th July 2014, the matter came up for hearing before another learned single judge of this honorable bench, of this honorable court. The matter was dismissed for default, as in the application was dismissed for default. The suit never ended up coming up for hearing. So therefore, the suit was never dismissed for default, or the suit never had to be restored to the file of this honorable court. However, the interlocutory application, the previous interlocutory application, was dismissed for default, despite completion of affidavits. Thereafter, my lord, in 2014, this happens. 10 years, it is an admitted fact, my lord. 10 years, no steps taken by the plaintiff. Nothing happens in the suit. The suit remains in complete suspended animation. And I will show your lordships the records that I have accessed from the website of this honorable court as well as from the CIS system, which show that there are no orders and there were no applications filed in the interim. Suddenly in 2024, new interlocutory application filed. That is GA number 2, seeking certain reliefs. Notice served upon us duly. We couldn't appear on the day that the matter was moved by my learned senior friend. A status quo order was passed by the coordinate bench, your lordship. Thereafter, your lordship, I come up with this application. Because it was realized as we were going through the new GA number 2 in 2024, that A, the plaint was not annexed, and that we hadn't been served with the writ of summons. And we haven't been served with the plaint. We checked the previous application, that is GA number 1, which was previously numbered as GA number 1929 of 2012. We found therein that, yes, the prayers of the plaint are stated. However, the copy of the plaint is not annexed to the application. So therefore, we were always at all material times in the dark about what was actually stated in the suit, what cause of action was stated in the suit. Because we were never served. And my lord, this is an admitted fact. Today, my lord, GA number 4, their application is an application seeking condonation of 12 years of delay. 2012, the suit filed. 2024, when the second interlocutory application came up. So it is in these
GA2 was filed in 2024.
GA2 was filed in 2024, Your Lordship. July 2024.
Yes.
Your Lordship, very few page numbers that I need to show to Your Lordship from the firstly, Your Lordship, page number 40 of GA number 3.
Yes.
Your Lordship, paragraph 20 there. This is, Your Lordship, the previous application, GA number 1, that was filed in 2012 by the plaintiffs. Paragraph 20, I place, Your Lordship. In the circumstances aforesaid, a cloud has been cast upon the right title and interest of the petitioner, that is the plaintiff, in the suit premises, that is the flats and the car parking spaces that are the subject matter of the suit as we understand it. And as such, the petitioner became entitled to seek and sought appropriate declarations from this honorable court. And as such, the plaintiff has filed this suit in the facts and circumstances more particularly stated in the plaint, to which the plaintiff shall crave reference at the hearing, and the statements in the plaint are all true and correct. The reliefs claimed in the plaint are as follows. Your Lordship, the reliefs in the plaint are listed. So, Your Lordship, the contents of paragraph 20 are very clear. They're craving reference to the plaint. It's not like they're annexing the plaint. This application, Your Lordship, was not moved ex parte. So it's not like there was Order 39, Rule 3A service effected upon us, where the plaint, the list of all the documents relied upon.
The order of injunction was obtained. It was obtained on contest.
There was no order of injunction obtained, Your Lordship.
No status quo order. There was a status quo order.
That's in the second GA.
Okay, in the first GA, it was dismissed for default.
It was dismissed for default ultimately, Your Lordship. That is the point. That is the point, Your Lordship. Because my learned senior friend has contended that this delay is condonable. Because even if I have not given, that is his assertion, that even if I have not given cogent explanations, I have taken all steps, I have tried to continue with this suit. What I am trying to say, Your Lordship, is that the plaintiff has been an indolent litigant. They have not taken any steps in the suit. They let their only interlocutory application, filed in 2012, be dismissed for default, whilst keeping the suit pending in this honorable court's file, which is already overflowing for the last 12 years. Your Lordship comes to page 63. Just two orders show what happened in the previous application. Page 63, Your Lordship. One of the first paragraphs.
Yes.
The learned counsel for the respondents assures the court that they would not cause any hindrance to the plaintiffs enjoying the common facilities, areas, and conveniences of 28/1 Shakespeare Shorney, Kolkata 70. This was our assurance. Such assurance is recorded. In case of breach of such assurance, the petitioner, as in the plaintiff, is given liberty to apply. It is also pointed out that the petitioner, that is the plaintiff, has not paid for these facilities since 1994. Mr. Malik submits that if bills are raised upon his clients, they would pay the admissible amount. Let that be done, and I order accordingly. Let affidavits be exchanged according to the following directions. Let affidavit in opposition be filed by 10th September 2012. List this application on 24th September 2012. Affidavit in reply, if any, may be filed in the meantime. So, my lord.
So, affidavits were filed in this application?
Yes, Your Lordship. Absolutely, Your Lordship. If I may just indicate, I will not take trouble Your Lordship with the contents of these affidavits, because they are not of grave importance. So if your lordship sees page 46, that is my affidavit in opposition to the previous application GA number 1, in which this order was passed, your lordship, that I showed your lordship at page 63 of this application. Your lordship, page 56. That's the affidavit in reply of the plaintiffs. Your lordship, again I come back to page 63. Direction for affidavits I showed your lordship from this order. The affidavits, your lordship. So the matter was directed to be listed. Then, my lord, page number 64, the very next page. Lordship will record the appearance. Mr. Dheeraj Trivedi, advocate, now senior advocate. Mr. Choyan Gupta, advocate. Mr. Rajesh Upadhyay, advocate. For the respondents, that's us. Since the plaintiff is not represented and none appears in support of GA number 1929 of 2012, despite the matter having appeared in the warning list. So, my lord, this GA number 1929, that's the first GA, the first application which was filed by the plaintiff. It had appeared in the warning list. Even then, the plaintiff did not come forward to move their application, despite having exchanged affidavits over a year ago.
My lord, may I take your lordship's leave? My lord, my lord junior is there. My lord, if he continues and concludes today, may I argue on the next day, my lord?
You want to argue on the next day? Anyway, let him conclude.
Because
today.
the division bench matter is being called. Obliged.
GA number 1929 of 2012 is dismissed for default, your lordship. To your lordship. To your lordship. This matter, their previous GA, where they hadn't even annexed the plaint, was dismissed for default. Now, your lordship, page number 65.
Anyway, this is your search report.
Yes, my search report, which shows that nothing has happened in the matter since the date of the passing of this order at page 64. Your lordship would kindly marks prom date in the search report. Kindly, your lordship, if your lordship would be so kind as to mark. I carried out the search from 8th July 2024 to 31st August 2020. Because 1st September 2020, the new CIS system came into existence. So since then, no matching orders or records found in that period. Yeah. From 7th July, last date of order, after that, no records found. Then, your lordship, page number 68. That's the CIS search. That merely shows that GA number 2, at that point of time when I accessed this, only GA number 2 had been filed.
GA2, when it is filed? This one?
It's the GA3.
No, GA3 is filed recently. That is 2024.
Yes, your lordship.
2000, and the other is GA4 is also filed in 2024. GA3, yes.
GA2, GA3, GA4, all filed in 2024.
So from 2014 till 2024, no application is filed.
Nothing. Your lordship sees, if your lordship comes to this column, that's the two applications at page 68.
Yes.
The GA1 of 2012, which was previously numbered as GA 1929 of 2012.
Yes.
Date of filing 18th July 2012. Next date 7th July 2014. Disposed. The order that I showed your lordship.
Yes.
Then GA2 2024. again, very interestingly, 18th July 2024 filed. Exactly 10 years, 12 years later, the application was filed. The new GA was filed. Your Lordship, page 71. That's the last page from the
Page
application.
70 is the report.
70 is the letter I wrote to the department seeking a report.
Oh, 71 is the report.
71 is the report. Your Lordship, with that having been shown to Your Lordship, I just think, Your Lordship, certain rules of the original side rules, which I've already cited in my written notes of arguments, that have also been extracted in the judgments, Your Lordship, if I may very swiftly show Your Lordship. Your Lordship, if Your Lordship kindly takes up the original side rules, Your Lordship.
Yes.
Your Lordship has?
Yes.
Your Lordship kindly comes to chapter 8, rule 6, Your Lordship. Chapter 8, rule 6.
Volume 1 টা দেখি এটা। Volume 2 দেখছি।
Volume 1, Your Lordship.
Volume 1 টা। ও এই তো। Yes.
Your Lordship, Lordship has rule 6. Summons to be delivered to the sheriff within 14 days. Except as hereinafter provided, every writ of summons shall be taken out and delivered to the sheriff for service within the local limits of the jurisdiction of this court, or for transmission for service elsewhere. A writ of summons shall have annexed thereto a copy of the plaint and of every document sued on, a copy of which is filed therewith. Unless an extension of time is obtained, it shall be taken out and delivered to the sheriff within 14 days from the filing of the plaint or the date of the order of amendment. So, Your Lordship, this 14-day timeline is fixed, and the word is shall. It's a mandatory requirement, Your Lordship. And again, I shall show Your Lordship very briefly that the point that I say, or that point that I argue, is that the 14-day period is provided here. Now, the question that had come up before previous coordinate benches, Your Lordship, was, yes, we can extend it, the rule state. How far can we extend it? The residuary article of the Limitation Act, which is that up to 3 years from the date of filing of the plaint, extensions can be granted. Beyond that, certainly the court has the power under Section 5 of the Limitation Act to condone the delay. But naturally, if there is a limitation period prescribed for something this essential, then, Your Lordship, beyond those 3 years, again, Section 5 will require a day-to-day explanation, and all the strictures that Section 5 has will have to be followed. The next rule, Your Lordship, to show how important this is, Rule 15 of the same chapter.
Yes.
Entering appearances to a writ. A defendant shall enter his appearance to a writ of summons by filing with the proper officer in the office of the registrar on or before the day fixed for his appearance in the writ, a memorandum in writing dated on the day of its delivery and containing the name and place of business of the defendant's advocate acting on the original side, or stating that the defendant defends in person and containing his name and place of residence. Form numbers 4 and 5. To your lordship, I cannot enter appearance in the main suit. I cannot file a wakalatnama in the main suit. I have to be served with a writ of summons of the suit.
Unless the summons is served, the suit cannot be proceeded also.
Precisely.
There is no question of your appearing.
Precisely, your lordship.
Cannot be proceeded with. Either it has to be dismissed or some time has to be granted.
Precisely. Your lordship has absolutely hit the nail on the head, your lordship. That without service of the summons upon me, I cannot suddenly do anything about this suit. Had the plaint also been annexed, maybe I could have come before your lordship seeking leave under this rule to file my wakalatnama, to file my written statement. But the plaint was nowhere annexed.
Yes, because you see, under the Order 39 Rule 2, when an injunction is obtained ex parte, definitely the plaint has to be served.
Precisely. But here, no ex parte. Here, if lordship sees the records of GA number 2,
GA2.
I'll show from GA3 itself. I've annexed the orders.
Yes. থাক সাইডে থাক এইখানে
Your lordship, page number 9 of GA number 3, your lordship.
Yes.
Your lordship sees at the top GA2 of 2024. This order is of GA2 of 2024. So appearance, your lordship. Unfortunately, Mr. Rupa Ghosh, it has gone down for the defendant, although it should be for the plaintiff. My lord, the first 3 paragraphs I place. GA number 2 of 2024 is filed by the plaintiff, praying for inter alia, temporary injunction, appointment of receiver, and other prayers in respect of flat numbers 1, 2, 3, and 4 on the ground floor, and 6 car parking spaces being numbered as 1A to 1F at 28 by 1 Shakespeare Sharni, Kolkata, 17. Affidavit of service is filed. None appears for the defendant. So, my lord, this application was taken out and served on us. We were unable to, for whatever reason, appear on that day. That is on 19th July 2024. So, my lord, it's not like
So copy of the application was received by you.
Yes, your lordship.
And you have specifically pleaded that in that said application, no copy of the plaint was annexed.
I'll show your lordship
Where is that pleadings?
I'll show your lordship. I'll show your lordship that because I've annexed a copy of that application again. GA number 2 also I've annexed. If your lordship comes to page number 18 of my application.
Yes.
Page number 18, paragraph 20.
Yes.
In the aforesaid circumstances, your petitioner was constrained to institute the above suit before this honorable court, claiming the following reliefs. The reliefs are stated. I'm not troubling your lordship. Page number 19, just the paragraph above paragraph 21.
Yes.
The contents of the plaint are all true and correct. Your petitioner craves leave to refer to a true copy of the plaint of the instant suit at the time of hearing of the instant application and treats such plaint as an integral part of the instant application. So, Your Lordship, GA number 1, I've shown Your Lordship plaint not annexed. GA number 2, plaint not annexed. As it fell from Your Lordship, until the writ of summons is served on me with the copy of the plaint and all the documents relied upon in the plaint, the process cannot start. The hearing of the suit cannot start. Interlocutory applications, as Your Lordship knows very well, under Section 94, Section 96 are supplemental proceedings. They are not primary proceedings, which the suit is.
Yes, you have covered this in your written notes of arguments also.
Yes, I've covered all of it in my written notes of arguments. I've referred to the rules as well. The rules that I showed Your Lordship.
Yes.
The only real thing that I have to do, because I'm pressing on all of this, Your Lordship, is because I have also placed reliance upon a judgment that my learned senior friend has placed reliance upon. Because he cites one portion, I cite the other portion.
Yes, yes.
Your Lordship gives me a moment. Yes. Origin that's Your Lordship, page number 17 of my note. Yes. So this is a judgment of the division bench of this honorable court, where the entire law relating to dismissal of suits on account of non-service of writ of summons, non-lodgement of writ of summons is essentially summarized and discussed very thoroughly. So, Your Lordship, if Your Lordship sees the fourth paragraph from the bottom at page number 17, it begins with a sentence, the object of service of writ of summons. Your Lordship has it?
Yes.
So, my learned senior friend, Mr. Ghosh, relies on this paragraph. He says the object of service of writ of summons on the defendant is to make him aware that a suit has been filed against him. If the defendant is otherwise aware of the institution of the suit, example by reason of participation in interlocutory proceedings or any parallel proceeding, the gravity of non-service or unduly delayed service of writ of summons would obviously be mitigated. Which is to say that if I have appeared in, say, an interlocutory application, I have contested the application, then the fact that the writ of summons was not served on me shouldn't automatically mean dismissal. It means that the court should ask itself, the court should carry out an objective analysis of whether the litigant has been prompt or not been prompt, whether they have instituted interlocutory proceedings. And
these facts are to be taken into consideration.
Essentially,
yes.
What I say, Your Lordship, is this: they file an interlocutory application, the interlocutory application gets dismissed for default in 2014.
Anyway, but prior to that, it came to the knowledge of the defendant.
It came
prior to that. So far, the filing of the suit and the pendency of the interlocutory application came to the knowledge of the defendant. However, thereafter it was dismissed and they did not take steps.
Yes, Your Lordship. But Your Lordship, what I say is in these facts, because I'll just revert again to Justice Ojoy Ray's judgment, wherein Your Lordship it is pointed out that merely because I have participated in interlocutory proceedings does not mean I have waived my right of service.
Justice Ojoy Ray's judgment was considered by the division bench.
Certainly it was. Certainly it was. And that is why, my lord, the next paragraph.
Yes.
It is true that procedure is the handmaid of justice, and procedural technicalities should not be allowed to defeat substantial justice. However, at the same time, an indolent litigant would not deserve sympathy